session from that date. So we will entertain a vote
What
To
date was
approve
it?
and not to release to public.
to approve and not to release to the public because it was executive session. Is there a vote for that? Or
What
motion?
date was that? I'm sorry,
November 1st.
I think I was.
Motion to approve the executive minutes from November 1st,
And not to release.
not to release.
Second.
All right, made by Bob and seconded by,
I missed that. Did I miss
Paul.
that meeting? That part of the meeting?
let's see, 1, 2, 3.
Yes, you
You did miss it. All right, all those in favor?
Aye.
Aye.
With
Abstention.
abstention.
Now the regulars?
All right, regular minutes from November 1st, 2018. Has everyone had a chance to review them?
Yeah.
Would anyone like to make a motion?
Motion to accept the regular minutes from November 1st.
Second.
Motion was made by Bob, second by Paul. All those in favor?
Aye.
Aye.
And I think I was
And-
there for that.
Yes.
Yes. All right, unanimous.
Now, if the board has reviewed the procedural rules, I'd like to get those finally signed off.
Here they are.
Kim's not here, but thank you for Kim for,
I did them.
oh, you did them. Thank you, Sari.
These were essentially the ones you sent to us?
Yes.
Oh, okay. It looked
There's a
pretty good.
couple copies on the table.
And it's based on the discussions we had.
Yes, a long time ago.
In
I
your
believe it was
script.
And
June.
it's far, far away.
And if you notice the administrative approval clause, it's in bold, I think it's section 503.
Okay.
That's the one that's going to be held up temporarily.
Yes,
until
as
we
of
vote it.
November 12th, 2018, this zoning administrator approval process shall be discontinued until such time as the board approves its reinstatement by vote of said board.
And that's because we have a new person coming in.
Right, and you want to make sure she's on board and knows
Right.
all the bylaws and everything before you allow that. And temporarily, I can do them for maybe another month. So if you approve all the changes as you discussed previously, with that, you can make a motion to approve, and I have an original here to sign.
Anyone want to make that
I'll make a
motion?
motion to approve the procedural rules
For the Board of Appeals.
for the
Second.
Board of Appeals, zoning Board of Appeals.
All right, motion was made by Jerry, and it is second by Paul. All those in favor?
Aye.
Aye. Unanimous.
Chairman, hurry up, you'll sign this.
Absolutely. Nice picture.
Yeah. It's like Washington, but
And if you could just date.
can't
We're
be.
going to give you the pens as we sign.
You have to
Looks
do them one letter at a time.
Then we'll file
Yeah.
that with the town clerk.
Very good. Nice to have that done.
It is very nice to have that done. Thank you.
Thank you, Sari.
Thank you.
Yes.
Kind of skipping around here. Board update, I'll just let everyone know for the record that Julian Suso reached out to me, Sari, and other department heads informing us that he's made the selection for the new ZBA administrator. Her name's Noreen Stockman, and going before the selectmen Monday night. So if anyone's available, I'll be in attendance. So that'd be nice to see,
STOCKMAN.
Yes.
yes, be nice to see some support for the board during that meeting. And future agenda items, does anyone have any? All right,
I'm going to take a 5-minute break.
seeing none, we'll
Yeah.
take a break until 6:30.
Thank you.
Good evening, and welcome back to the November 29th meeting of the Zoning Board of Appeals. Earlier, we had an agenda item at 6 o'clock regarding an executive session. We also took care of our open meeting or agenda items, the minutes, board update, procedural rules and policy, and future agenda items. That leaves us here at 6:30 with 5 new hearings, and I'll ask the public to please silence their cell phones at this time, and I'll also introduce the board. To my far right, your left, is Jerry Patamas. He's an associate member of the board, followed by Ken Foreman. He's the vice chairman of the board. My name is Terrence Hurry. I'm the chair of the board. To my left is Paul Murphy. He is a full voting member of the board, and Bob Dugan, who is another associate member of the board. With us tonight, post-retirement, is Sari Boudreau. No longer the zoning administrator, but what do we call you, Sari?
It's me.
Just Sari is here, and
Subject matter expert.
we also have Joe Robbins, our recording secretary, here tonight. The Zoning Board of Appeals is charged with applying the zoning bylaws for the town of Falmouth and considers requests for special permits, variances, and appeals as provided in the bylaws, which have been approved by town meeting and the Attorney General's Office for the Commonwealth. And all decisions that we make are done through the public hearing process. The board's goal is to hear testimony from the applicants and the public, and also to allow full and fair discussion of the project prior to rendering a decision. To begin each hearing, the clerk will read the public announcement of the hearing and present any pertinent information from the file, such as referrals from any town departments and summarizing correspondences to and from the board. The applicant or the applicant's representative will then have 15 minutes to make a presentation, and then time may be extended by vote of the board if we deem necessary. The board will then ask questions of the applicant, and then the board will be, then the public will be invited to comment. We'll let everyone settle in for a second.
A lot of people. What's the,
The bus must have
I
arrived.
guess so.
They were sitting outside.
oh, wow. Where's Oakwood?
As I was saying, the public will be invited to comment after we ask questions of the applicant. Public comments should be directed only toward the project. I also ask you to please refrain from any personal or derogatory statements. Any public comment can include an opinion in favor or in opposition, or it just might be simply a question about the nature of the project. The chair will limit discussion in the interest of time if comments become too repetitive. All members of the public wishing to speak should wait to be recognized by the chair and should come to the podium to the right, and please state your name and address for the record. And usually we limit public comment to 2 minutes per person, and we usually do cut it off after a certain amount of time. We will then either close or continue the hearing once the board is satisfied that we've received enough information that's been presented through testimony as well as in the file to make a decision. By vote and motion of the board, the hearing will be closed. In the alternative, we may continue the hearing to a future date and time certain. After the hearing is closed, no more testimony may be taken. The board may then further discuss the project among ourselves and make a motion to either approve or deny would be made and voted upon. A motion will include a summary of key findings and conditions. An affirmative vote of 4 members, which is a supermajority, is required for approvals of motions on special permits, variances, and appeals. A split vote, such as a 3-2 vote, is a failure to carry and would result in a denial of the project. Under Massachusetts general law, if a special permit is denied, the applicant cannot return to the board for 2 years unless the project is substantially different. So as I said, to start this off, we do have 5 new hearings tonight, and we will start with application 87-18, Dupuy, 123, Sari, can you help me with the name of that road?
Adamancet.
Adamancet Road in Hatchville. And I will be appointing Paul Murphy as the clerk tonight.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you're hereby notified that Paul R. Dupuy Jr., trustee of Falmouth, Mass., applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C of the Code of Falmouth to raise and reconstruct the pre-existing non-conforming single-family dwelling on subject property known as 123 Adamancet Road in Hatchville. Correspondence. We've got, do we have any letters? Did you want me to talk about letters first?
No, just go ahead and read the referrals first.
Oh, referrals,
Or
right, referrals, sorry.
Make note. of the-
Engineering, the standard comments about runoff and whatnot. Fire department, no comment. Conservation Commission had no comment. The planning office had no comment. The water department, 2 existing acceptable services exist. The assessor's office had no comment, and that is it for,
And what's the note over there on the other?
we have 1 letter of support for the project.
Okay, and for the applicant?
Good evening, Mr. Hurry and members of the board. I'm Bob Ament. I'm an attorney in Falmouth. I also happen to be a co-trustee of the Adamancet 1997 nominee trust, which owns the subject property. I've been a trustee since 1997. I'm very familiar with the subject property. The applicant was filed by my co-trustee, Paul Dupuy, whose family has owned the almost 100 acres along the southern boundary of Coonamessett Pond, extending to Hatchville Road and extending out to Sandwich Road for 60 years. On this map, I've indicated the location of the lot in question. It is this area right here, blown up behind you. Ignore these colored houses. This plan was actually been used on a number of occasions, beginning back in 2005, to demonstrate the land all in yellow that was purchased by the town of Falmouth. The town of Falmouth owns significant open space across the street from this locus. And that purchase around 2005 also is next to the Mount Sousa Conservation. Great deal of protected land and significant privacy for Adamancet Road. So this lot was created around in the 1950s. The house was built in 1950. There was actually a second cottage on the property that after it was built at the same time. The proposal and the reason for a special permit request is a desire to take down this house, which is quite old and in considerable disrepair, although habitable with a bit of work, and to be able to construct a new house on this lot, which is 1.33 acres in size. So it's a fairly large lot, surrounded by other large lots and across the street from conservation property. The proposal involves a new septic system, which will be of significant advantage to the environment. The present house is non-conforming in 2 respects. It's only 15.7 feet from Adamancet Road, and it's only 40 feet from the pond. Today, a structure needs to be 50 feet from the pond and 25 feet from the street. The new house will not increase the nonconformity at all, but will include construction within the setbacks no closer than existing to the street or the pond. The existing house has 3 bedrooms, and the new house will have 3 bedrooms. Because the location is all within jurisdiction of the Conservation Commission, an order of conditions was required. It has been obtained, The Conservation Commission has approved the proposed house, requiring almost 5,000 square feet of new mitigation plantings in areas that presently are not vegetated. In addition, the Board of Health has approved the new septic system, which will replace the existing cesspool, which is closer to the pond. The new system will be as far away as possible from the pond. I have both in paper and can show you perhaps better on the board, an existing conditions plan that's before you. This is the plan of the site plan of the proposed new house. Shows the location of the septic system. This is the house, again, no closer to the street and no closer to the pond than existing. And you can see the substantial areas of mitigation planting that have been required by the Conservation Commission. Adamancet Road is a dead-end road. There are only two houses farther along the road, one on the lot here and another lot right here. You have, as is mentioned, a letter from Rick Olivier, who lives in this property, saying he's in support of the granting of the special permit. I'm also going to try to show you house plans. I think I can do it. Before you is just a foundation plan. This is a floor plan. It's still a relatively small house with 3 bedrooms, as you can see on the second floor. It's a very narrow house, again, because there isn't much distance between these existing setbacks. And one thing I'd like to point out is that this side of the house facing the street to this point is only 21 feet high. Not a very tall house. The way it's designed, by turning it back here, it's about 28 feet high, but close to the street, it's only 21 feet. So the profile is pretty small. The closest other structure to this site is 360 feet away. So I think you can easily conclude that with no increase in the number of bedrooms, a new septic system, a new house replacing a house that needs replacement, this is all beneficial. It's beneficial to the environment with a new septic system and all of that mitigation planting, and that it's not substantially more detrimental than the existing nonconformance, which is your test under Section 243 of the bylaw. And in terms of suitability of the site and the adequacy of area and so on, as I've said, it's 1.33 acre site. It's the use is not nonconforming, that is, use of a house. And I think you ought to feel comfortable in granting the special permit so that a new house can be built. I'd be happy to answer any questions if you have them.
Bob, do you want to start us off with questions?
Just regarding the basement, I noticed there's large windows down there, but that's storage only?
It's marked as storage. I actually think that it would be possible to provide for egress, and that would require just going to the building department to change the plan. I don't think there should be a restriction on it as long as the number of bedrooms isn't increased.
That's all I have.
Paul, any questions?
No questions.
Ken?
I don't have any questions.
No questions.
Okay. No questions from me either.
I have,
Sorry?
is there in the file, is the Board of Health, Conservation Commission's order of conditions in the file?
I didn't check.
I think I can answer that question, Suri. I think there isn't, and I intended to give you both a copy for your file of the Conservation Commission order of conditions and the letter from the Board of Health approving the septic system.
Thank you, Bob. You could stamp those and put those in the record,
Certainly.
please.
Thank you.
please mark them that they were submitted by Attorney Ament?
Yes.
Thank you. Thank you, Bob.
All right, we'll turn it to the public. Does any questions, comments, concerns regarding this project? Anyone out there? There's a lot of you tonight.
It must be,
Must be here for another project then. All right, coming back to the board, how would the board like to proceed?
Make a motion to, oh, wait, close the hearing.
All right, motion to close the hearing by Jerry. Is there a second?
Second.
Second by Paul. All those in favor?
Aye.
And how would the board like to proceed regarding this project?
Motion to approve.
I'll second.
Move to approve by Jerry and second by Ken. Moving on to findings.
It's consistent with 240-216. It's not more detrimental. And it's consistent with 240-216, adequacy of the site, suitability of the site, impact on traffic, impact on the neighborhood. I'm just abbreviating these. Adequacy of sewage disposal, that we got a Board of Health approval, and adequacy of public and other utilities.
Yeah, they're putting in a new septic, so that's an improvement. Their setbacks remain, are no more detrimental, they're saying. Very modest increase in lot coverage, but they're well below the lot coverage limits. And well below the height limit as well.
In compliance with the height.
Yeah.
Do you want to make a comment on the remaining 3 bedrooms?
No increase in bedrooms? I forget, how many did they apply for?
Right. There's no increase in bedrooms, and the basement will not, there's no intent to put bedrooms in the basement. Because he may get that approved as habitable. Right?
Yeah, I didn't hear
That we could,
Attorney Ament say that.
He said that there could be proper egress and that
Right.
he doesn't wish a condition that there not be habitable space.
Right.
There's certainly no bedrooms allowed because there's 3 bedrooms on the existing, on the proposed second floor.
We'll at least find out there's storage only proposed for now, at least for findings.
Well, storage and possible egress and possible habitable. He did state that.
Right.
We don't want to close that door.
Is that a pun?
Should make note of the conservation orders of conditions.
And Board of Health.
And that septic was rated for 3 bedrooms? Okay.
All right.
I think
Conditions?
the findings on the 50-foot under 240-68D for the 40-foot, which is non-conforming, required
Right.
to be 50 feet.
I think we did,
I'll put that in there.
yeah, we did, but
No increase in
they're not
setbacks.
increasing. That was a finding.
Conditions?
per plan.
No increase in bedrooms.
No more than 3 bedrooms. And no bedrooms in
Lower
basement.
level,
Okay.
basement.
Anything else?
Seems good.
Should we adopt Concom's findings?
It's up to the board.
I always like to do that. Strength.
Adopt order conditions.
All right, anything else? All right, motion to approve was made by Jerry and second by Ed. All those, I'm
Ken.
sorry, Ken.
What'd you say?
He's not here tonight. All those in favor?
Aye.
Aye.
Thank you.
next, we have application 88-18, Latitude 41 North LLC, 34 Oakwood Ave in Falmouth.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you're hereby notified that Latitude 41 North LLC of Fort Myers, Florida, filed an appeal with the Falmouth Town Clerk pursuant to MGL Chapter 40A, Sections 8 and 15, and 240-202 of the Code of Falmouth, appealing the building commissioner's determination that the parking and storage of motor vehicles does not violate zoning bylaws on subject property known as 34 Oakwood Avenue, Falmouth, Mass. For referrals, we don't have anything.
No.
And what do we have for correspondence? Letters?
There's communication between the attorneys and the staff.
There's communication between the attorneys and the staff.
And for the applicant?
For the
I'm sorry,
applicant,
for the appellant, I guess?
my name is Brian Wall. I'm an attorney from Sandwich, and I represent the petitioner. And with me tonight is my client to my right, Anthony Ursacelli, and I'm going to refer to him as Tony, just so I don't twist my tongues. I think with regard to the correspondence, there was also an email from a neighbor and an email from the owner of the subject property, too.
Well, it's been in the file for a while, so,
Right.
but there's no letters about, there's emails. but
Right.
That's what he was asking specifically.
Okay, I'm
so
sorry.
I
Nothing to
apologize
hand
for it.
out?
It's all in the file.
Yeah, you want me to- something I can hand, I don't really
No.
think I can hand it
No,
out.
there's nothing.
Pass
No.
it down.
So then, if I may, Mr. Chairman, I'll begin. As I said, I represent Latitude 41 North LLC, which is the owner of property at 29 Oakwood Avenue in Falmouth. And again, for ease of reference, I'm just going to refer to my client as Tony. He's the owner of the LLC. This is an appeal of a decision of the building commissioner denying a request for enforcement regarding neighboring property at 34 Oakwood Avenue, owned by a Terrell Hollywood Gin, I think, and I might refer to him by Terrell, not to be informal, but just to make it easier. And just to give you a preview, the issue at hand is whether or not parking and storage of motor vehicles may take place in a residential zone without any principal use of the property. So by way of background, Tony's property is a 7,237 square foot property that's improved with a single-family dwelling. Directly behind his property, in the rear, is a landlocked piece of property owned by Terrell, which is 9,523 square feet. The Department of Inspectional Services has determined that this property is unbuildable for a variety of reasons, including that it lacks frontage, and I don't think that that is disputed. Both of the properties are in an RC residential zoning district. Terrell is a resident of California, and as far as we understand, he's a very experienced real estate owner. He owns properties on Martha's Vineyard. He works and lives and owns property in California and also owns property in Florida. He purchased the subject property in 2017 at a foreclosure sale for $25,379. And it's our understanding that he was well aware of the fact that the property was unbuildable at the time that he purchased it, obviously as evidenced by the purchase price. And he has since told my client that he bought the property to serve as a parking lot so that he can park his vehicles when he goes to Martha's Vineyard. And as you know, this particular area of town is pretty close to the parking lot for the Steamship Authority. And indeed, in a text message that Mr. Terrell sent to my client at one point during this proceeding, he said, "I have 10 vehicles, including a bus, and I don't intend to park all of them there yet." Since he's purchased the land, Terrell has in fact been parking motor vehicles on the property and storing them, and these include a van with a mattress in it and an RV that is approximately 34 feet long with a gross vehicle weight of over 13,000 pounds. Both of these vehicles are registered in California and have California license plates. The RV has been there since May and hasn't moved since then. So far, all of the vehicles on the property appear to be owned by Terrell. However, in an email to the zoning enforcement officer, Ollie Fitzpatrick, he said that he reserved the right to rent out spaces on the property. Tony contends that the use of this property essentially as a parking lot in a residential district is not allowed, and he retained my services, and we filed a request for enforcement to the town. And essentially, we made two arguments, that the parking of motor vehicles as a principal use is not allowed in a residential district, but could be allowed as an accessory to a single-family dwelling. But with no single-family dwelling on the lot, obviously, there can't be an accessory use, and therefore there can be no parking of motor vehicles. And secondly, specifically with the motor home, there are provisions in the Falmouth zoning bylaw addressing them, and a special permit is needed to park a motor home on a property, and there is no special permit at issue here in this case. Those two arguments were supported by the following analysis, and I don't mean to drone on or be boring, but the details in this particular matter. This is what we said to the zoning enforcement officer. In Falmouth, under Chapter 240, Section 17, essentially all uses of property are prohibited unless expressly allowed. And then when one goes to the RC residential district, what's permitted as of right are one-family detached houses, certain community services, agriculture, and some other uses that are clearly not relevant. By accessory uses are allowed such uses that are customarily incidental to the foregoing principal uses. And then by special permit, parking of any motorhome, travel trailer, or fifth wheel trailer not located within the minimum front, side, or rear yard setback requirements, or parking any commercial registered vehicle with a gross vehicle weight of more than 13,000 pounds. So the argument went like this. Parking of motor vehicles is not a use that's defined in the residential district as a principal use, but is allowed as an accessory, incidental and customary to single-family dwelling use under Section 240-22. Further, the parking of a motor home may be allowed as an accessory use, but only with a special permit, and then only if it's not parked within the required minimum setbacks. Terrell's lot is vacant. There's no principal use on the lot. Consequently, parking of motor vehicles on the property cannot, by definition, be incidental to or customarily found with a principal use, because there is no principal use. If the property were improved with a single-family home, then the parking of motor vehicles could be considered accessory. And in fact, under Section 240-108 of the bylaw, it says that if one builds a 2+ bedroom dwelling, one must have at least 2 parking spaces. So clearly, under your bylaw, parking is incidental. It's not an allowed principal use. The problem with the subject property is it's been determined unbuildable, and therefore it is incapable of supporting any primary use. And therefore it necessarily follows that without a primary use, there can't be an accessory, and without an accessory, there can't be parking of motor vehicles. And with regard to the motorhome, it's defined in your bylaw at Section 240-13 as an automotive vehicle built on a truck or bus chassis and equipped as a self-contained traveling home. The RV at issue clearly meets this definition, and therefore it requires a special permit, which it does not have. The building department reviewed the request and issued a 2-paragraph letter in response. The response did not address the issue of parking of cars, but did address the RV, and the building commissioner wrote the following. The parking of a registered RV within the minimum front, side, or rear yard setbacks is, in his opinion, allowed by Chapter 240-23G4A. And my client respectfully disagrees and appeals tonight to this board. And we think that the building commissioner's decision is incorrect because it incorrectly interprets Section 240-23G4A. This particular provision of the bylaw, which I've already mentioned, allows as an accessory use, and remember the argument is there is no principle, as an accessory use, the parking of a motorhome away from neighboring properties not within the minimum setback area. The building commissioner essentially skipped over the word not and found that an RV could be able to be parked within the minimum front yard setback. So our argument is that not only does it not comply with the language of the particular provision at issue, but it's also contrary to the intent of the bylaw. The intent of the bylaw is clearly to protect property owners from having vehicles parked right on the edge of their property line. And what the building commissioner's decision does is it seems to expressly allow it. Furthermore, the building commissioner's decision is flawed in the sense that he can't get to the point of saying that the special permit is eligible, because that is only allowed as an accessory use and there's no principal use. So it's flawed for that reason as well. So our argument is that the building commissioner essentially found that parking can be a standalone use on the subject property, but that flies in the face of your zoning bylaw because Article 5 does not name parking as a primary use. And again, since the parking of the motorhome is specifically designated by special permit, there isn't one, and therefore it can't be there. The building commissioner's decision also has some pragmatic problems. Section 240-109E of the zoning bylaw prohibits private parking areas within 5 feet of any property line. So the building commissioner said that the RV could be there because it was within the minimum front yard setback. This particular piece of property is landlocked, so there is no front yard, side yard, or rear yard. I think it would be reasonable to say that there are 4 side yards, and the setback to a side yard in this particular district is 10 feet. And the problem that Mr. Haloudjian runs into is that, assuming for a minute the building inspector was correct, which we dispute, physically it can't be complied with, because in order to comply with the building commissioner's decision, the parking must be within the setback, which is 10 feet, but it can't be within 5 feet because of 240, section 109. And an average motor vehicle is 6 or 7 feet wide, so it can't be more than 5 feet away from the property line and within 10 feet. It's just physically not possible. Finally, the building commissioner's decision implicates another provision of the zoning bylaw, which is 240, section 28J. This section requires a special permit from the planning board for a common driveway. This particular lot is landlocked, and it serves more than 3 lots. So it triggers this particular section, which requires a special permit for use. So if the board is not persuaded by the arguments being made tonight, the use of the lot would require a special permit under 248, section 28J, which also Mr. Haloudjian Terrell does not have. And for all of these reasons, we think the building commissioner's decision respectfully was erroneous and should be overturned. And Tony's here tonight. He wants to say something on a more human level than all of this legal argument. If I could yield the podium to him for just a minute.
And you have about 5 minutes, just so you know.
Thank you.
I'll be brief. I want to thank the board, thank the residents for time. So, my wife and I own a vacation home on 29 Oakwood. We vacationed in the Northeast for a long time. Falmouth was always our favorite. My wife actually grew up on Cape Cod. So when it was time to buy a vacation home, it was a no-brainer for us. The feel, the neighborhood, the people in the area. So we're fortunate enough to finally buy a vacation home. And shortly after we closed, the vacant lot next to us, if I can submit this.
Good. If you could hand it over here, we'll stamp it in. Thank you.
A 30-year-old van parks on the lot, a van that has a mattress and curtains in it. And then a couple months later, a 34-foot RV is parked on the lot next to us. The lot's never been maintained. You can see by the pictures how unsightly it is. I come from Florida. I've always had a vacant lot in the community or next to me. So my expectations weren't that. And I think most people in the room probably would feel the same way. So I understand the purpose of zoning. And I respect that. And it's for lot owners, property owners to have peaceful enjoyment of their property. Also to protect the values of their property as well as the values within the community. I've seen towns, we've all seen towns with poor zoning, where you have multifamily, high-rise next to low-rise, or commercial next to residential. And if you drive through the streets of Falmouth, that's not what you see. You see quaint residential neighborhoods, New England type of feel. So, as a layman, it's hard to understand how a lot that will never be built on can be sanctioned by the town to be long-term vehicle storage. The owner of that lot is not a resident of the area, nor does he support any local businesses. He lives in California. He uses that as a parking lot. He has 2 vehicles. In a text he sent me, he said, hey, I have 10 vehicles, and I don't plan on parking them all there yet. You know, so can you use it a parking lot? Well, that's Mr. Wall's legalese, but from our perspective, if the lot is unbuildable and you have no utilities, you have no utility easement, how can it support any secondary use? If you had a house, your kids can camp out in the back, and, you know, every 2 hours they can use the facilities inside the home. There is none of that there. You can't have a garden, there's no water. How can you use it for a parking lot? So truly, if we say that this lot that has no other use, because you can't build a house, and you can't habitate it, can only be used for parking lots. So the highest and best use for this lot is a parking lot. And the highest and best use for any non-conforming lot, non-buildable lot in the town of Falmouth would be long-term vehicle storage. And I can't, as a layman, can't understand how that, by the intent of an ordinance, or by the letter of an ordinance, would say, okay, non-buildable lots, can't build a house, but long-term vehicle storage, where no requirement to maintain it. He lives in California. Those could be there for 2, 3, 4 years with anybody coming to visit them, anybody coming to maintain it. An RV has a 100-gallon diesel gas tank. So let's say that it had I don't know if it's possible, a 25-year-old truck might have a pinhole leak in the fuel system. We would never know. It has a 100-gallon sewage storage that no one checks on. You know, what could possibly go wrong? Besides the fact the lot's never been maintained, there's no requirement to maintain it. So in 5 years, that RV or van could have weeds surrounding it. I don't think that's the intention. It's definitely not protecting anybody's values in the area. And then something you don't think about, if you read Terrell's letter, and I also can't pronounce his last name, he was very proud of the fact that there are no rodents in his RV. But in case a rodent does get in, he has rodent traps. So my wife read that, and she got creeped out just thinking about rodents getting into an RV in a trap, sitting there for 2, 3, 4 years unattended. Everybody think about that in a lot next to you.
Thank you. We've hit the 15-minute mark in terms of
Okay.
the
I'm
presentation.
just about done. I just want to thank the board for hearing me. Thank you.
Thank you. On to board questions. Jerry, do you want to start us off?
No question specifically, but I think I, at this point, agree that we should overrule the building commissioner's decision. I think I might be confused on that, but,
We'll weigh in on that soon, but
okay, but I mean, it's part of, okay.
Rich, they're gonna have board discussion, and then they'll ask for public comment.
I'm sorry, but we're representing the gentleman who owns the lot.
Chairman, did you want to ask anything of Brian Wall and the other person before you entertain?
right, we'll do
Mr.
that
Hellowen?
before we entertain him.
Okay, I have no
Sorry.
questions
I
of
didn't
Mr. Walden.
realize
No, I didn't either. Mr. Eads did not inform me that he will be here representing Mr. Haljowen.
Okay.
So,
Well, we'll continue with the line of questioning for Attorney Wall and his client, and
okay, then you'll get to Mr. Eads, okay.
we will.
Are you to me?
Ken?
I'm a little confused because, and I'm not finding a good plot plan here,
A good what?
a plot plan. And I'm a little confused about how the vehicles, if this is a landlocked parcel, is there an easement of some kind? How do the vehicles get onto the lot? Do they parachute them in, or?
You have to get to the podium,
Yeah,
sir.
I can explain. So from Oakwood Avenue, there's a 10-foot winding right-of-way over, access easement over Tony's property.
Okay,
that
so
gets from Oakwood to the back.
it's not owned in fee, it's an easement that.
That's correct, right? That it's, the lot is completely landlocked as far as fee simple ownership is concerned. There's this right of access across Tony's property and another property. That's when I mentioned about the common driveway. There are a property on one side of the access easement and on the other, and then this property is behind. And I can submit something after, or if this is continued, but basically, if you could imagine in your mind's eye, Tony's property fronts on Oakwood.
Okay, I see this now.
Behind it, yeah, there's a lot behind it, and then the house behind that fronts on the road on the other side. This is kind of crammed into the middle. It did have a house at one time that I understand. It's gone now. I think it burned, and it was not built back within that
And this parcel is only
It
17,000.
was a shed.
shed.
This parcel is only 17,000 square feet, is that
The lot at issue is only 9,000 square feet.
9,000?
Yeah, it's 9,523 square feet. It's less than 10,000.
Okay. All right, that's it for me at the moment.
Thank you.
And just to be clear, that 10-foot right-of-way easement, that's the only legal access to the property?
That's my understanding, yes. And it doesn't front on any road whatsoever. It's completely surrounded by other residential properties.
And you referenced the building commissioner's response, and he quoted the special permit section 240-23G4A.
Yes.
And he cited that as a reason for the RV to be on the property?
Yes, if I may, I could read the paragraph, and I'm sure this is it's part of my exhibits to my letter. It says, Dear Attorney Wall, pursuant to your enforcement request dated August 20th, 2018, this correspondence is to advise you that based upon the information provided by the property owner and inspections performed by this office, the parking of the property owner's registered RV within the minimum front, side, parentheses, parking of rear yard setbacks, Chapter 240-23G4A, in my opinion, does not constitute a violation of the zoning bylaws.
240-23G is accessory uses.
Yes.
Right. On that page, it starts off, it says at the top, it says the following accessory uses are allowed in RC district.
Right.
And then it goes on, 4 talks about outside parking of commercial light panel trucks. And then A says, any motorhome, travel trailer, or fifth wheel trailer not located within the minimum front, side, parking, or rear yard setbacks.
But that would need the benefit of a special permit.
And it would need a special permit. It has to be accessory, and it needs a special permit. And it can't be within the side yard setbacks.
And the property it doesn't have the benefit of a special permit.
Right, our argument is it doesn't have a principal use, so therefore you can never logically get to this point. But if you did, it would need a special permit, and it could not be within the setback. And the building inspector said it must be within the setback.
Thank you. Paul?
Yeah, Brian, when was the easement created and what was it specifically for? What's the language say?
I did not do a full title search on this, so I can tell you what I think, but without the facts to back it up. The lot Mr. Shelley's lot has this winding access that clearly does provide access to the back lot, this landlocked piece. So it was to create some means of access, but without any ability to use the lot, the access is frankly useless too.
Well, I mean, it's not that it's not buildable, because under a comprehensive permit, you don't even need frontage. So it's not an unbuildable lot, but I think it's important to maybe take a look at the easement and see what it was specifically, what it authorizes.
Okay.
Get a better, you know, I would say so. Yeah, I mean, obviously, it's some form of access to use this property, I would say, otherwise it wouldn't be there. I don't know, I mean, I guess that's really my only question at this point. What the easement's for, when it was created, might help us out a little.
Okay. But to your point of the comprehensive permit, if a property owner filed for such, I would agree that they get waivers from zoning requirements. But that's not what the use is. It's parking, and I think the key thing to understand our argument too is it's not merely parking, because I would suggest to the board, for example, here on Main Street, parking is a transitory thing, comes and goes. This is long-term storage of multiple motor vehicles that are, and I think Tony's point was well taken too. I would submit to the board the reason why you need principal use for an accessory use is to have a use and control over the property. You don't want to have a use that needs supervision occurring without an owner being around. And I think that's one of the fundamental problems with this.
Yeah, no, rhetorically speaking, what about bicycles?
Again, I don't think that there's any use that's allowed if you go through the
So
resident.
no beneficial use of your property if it's not, so no beneficial use of the property if it's not suitable for single-family purposes under our bylaw?
That would be my argument.
That's just, I'm just
Yeah.
throwing that out there. I'm not saying
Yeah.
that you're right or wrong, I just,
No, and I think that's correct, because again, bicycles, it would follow the same logical argument as the parking in the sense that, I mean, with all due respect, think about it. If you have a single-family home and you have children or adults that like to ride bicycles, you've got bicycles. I've got 3 or 4 of them on my front porch right now. You put up a bike rack with 50 bikes, you're talking about a business. You know, if for example, in Torella, I don't think is doing this, but to your point, if he said, hey, I've got a lot over here and you can park your bike for free because I'm against climate change and I want everyone to ride their bike into the ferry, that's a business. That would require supervision, conditions from this board. And to Tony's point, this is a residential neighborhood. It's not something that you would expect.
are they his vehicles? Are they all registered?
As far as I know, the 2 vehicles that are there now are registered in California, and we think that they belong to him. But again, to Tony's point, we don't have access to run the VINs in the
Right.
RV. And in one of our conversations about tonight's hearing, I said to Tony, when you live in a neighborhood, you kind of know the cars in the neighborhood. I know who my neighbors' cars are. I know when the husband and wife are home across the street or when their daughter's back from college. If cars come and go and you don't know who they belong to, it's a bit of a unsettling feeling and risk.
All right, so your contention is he has the right to grow trees only?
Maybe a vegetable garden, and I'm not being facetious. He
Yeah,
can probably
okay.
make some
No, I'm
use.
not either.
But I think your zoning bylaw prohibits camping. It prohibits uses of property unless it's allowed. And this district is intended for single-family residential use, as well as some of the other uses that I mentioned.
Okay,
Anything
all right,
else, Bob?
thank you. No, that's all for now, thanks.
Bob?
Just regarding the easement, I would like to know if the easement is deeded. And also, do the adjacent properties have any access to an easement over this property?
My understanding is that the right of access is in a deed, so it's reserved in the sense that when that lot was conveyed, it was reserved. So it's deeded. I don't think it's a separate item instrument. But again, I didn't think that was a real relevant issue, so I don't want to say things that I don't know as a matter of fact.
And if there ever was a structure that was allowed on this property, wouldn't that limit where you could actually put your parking?
No, because I don't think that are you saying that the frontage inside there?
If you had the case where there was a possibility of putting a structure on that property,
Yes.
it would also limit where you actually could do the current parking, correct?
I'm still not sure I understand your question. In other words.
So if you built the structure, and
Yep.
now you have a building envelope,
Yes,
now you have a septic system,
yes.
you probably, it's such a small lot for what's being parked there currently. It would limit where you could actually public those,
Oh, absolutely, yeah.
That size.
So if a structure were to be built, as you suggested, the 109, I think it's 109, says you can't park within 5 feet of a property line. And so you would have to fit your customary and incidental parking to that structure away from the side yard setbacks.
that's all I have.
Any other questions from the board at this time? And, Sari, you said that there was an attorney representing the landowner?
Apparently, Mr. Eads just got up and notified us that I had no notice, so I apologize. There was a letter from the property owner that we received yesterday, I believe. It is a lengthy one, which is why the clerk did not read it, but it is there for all the board to see. And Attorney Rich Eads.
May?
Geez, this is a weird, do you have anything from Terrell authorizing you on his behalf? Because I didn't get anything submitted to the file, Rich.
Yes.
Even his letter didn't state it. You can just give a copy to the clerk, and he'll stamp it in for the file. Thank
I'm
you.
not the clerk.
All in. Thank you. Okay, this is a bit of a surprise because we weren't expecting you, but guess we can afford you the same amount of time that we gave
Well,
the applicant, 15 minutes. And if
I appreciate that.
if you're on the under on that, we'd also appreciate that as well, so.
My name is Rich Eads. I'm an attorney here in Falmouth over at 49 Locust Street. With me is my partner, Will Eads, and Sari. We stopped by the zoning office yesterday and talked with the lady who was there, identified ourselves, that kind of thing.
I'm sorry, there was nothing submitted to the file, and usually there's an authorization, so I was not notified, but then again, I'm not in the office any longer.
Apparently, that's true enough. So, we were retained at the beginning of the week, so we're catching up as well. And I had a presentation planned, but after the applicant's presentation, I feel a need to respond to some of the things that have been said. In our world today, there's a term called fake news. People say things that they may or may not be able to prove. We obviously have had the benefit of speaking with Mr. Hallowin, and I'd like to immediately indicate that at the present time, there is an RV on the vacant lot owned by Mr. Hallowin with a deeded right-of-way to access it. At one point, there was a van, but that is no longer there. Mr. Hallowin has never mentioned to us an intent to run a parking lot for profit out of this lot. He has expressed that his intent was to acquire a parcel of land here in Falmouth. He lives in California. He regularly comes east and he has a house out on Martha's Vineyard. Last summer, or this summer, after acquiring the property in the end of 2017, he and his wife came east in the RV, which he owns. And their intent was, having spent time out on Martha's Vineyard, not on this land, to return to California. They were expecting a baby, and there was medical issues that arose, and they had to go back to California without the RV. So they left it parked in the center of the lot. It's not within any of the setback areas, and covered it with a cover to protect it and keep it safe. So they have had their baby. However, the baby's been in a NICU for the last 5 weeks, so he couldn't be here. So he called to find someone to represent him, and we agreed to do so earlier this week. So the funny thing about lawyers' presentations is that they like to emphasize what works for them. And what works for the appeal in this case is to keep talking about principal uses, accessory uses, and that kind of thing, because it's distracting. Takes the eye off what's really going on here. As was pointed out by a member of the Zoning Board of Appeals, contrary to the assertions made, there is some purposes that are in fact principal purposes for which this lot could be used. It's a vacant lot with a deeded right-of-way to access it. And the one that comes to mind is 240 section -21, sub A, agriculture, horticulture, floriculture. And that doesn't have to be, and it isn't, for any commercial purpose, but it is certainly something that Mr. Hallowin is interested in. Also, he would like to park his car there when he comes east and goes to Martha's Vineyard. It's his property. He has the right to park it there. I find it a little hard to believe that in Falmouth, someone who owns a vacant lot can't park his car on it, because that's what's being suggested here. That strikes me as being a virtual impossibility. Now, an RV is bigger than a car, but they weren't intending to leave it, and they had legitimate reasons to move it away. The applicant has suggested that parking of motor vehicles is not allowed as of right in a residential district as a principal use. Well, of course it's not. What's the point in saying something like that? We would suggest, however, that parking is something that all of us have a right to do. The case that is mentioned in the applicant's letter is one called Maxent against the Town of Harvard. This was kind of fun because I used to be town council in Harvard for 20 years, so I'm kind of familiar with the case. And he cites it for the principle of, he cites it for purposes relating to customary and incidental. And yeah, the case talks about that, but what the case also says is the court says, the Supreme Judicial Court says sorry to talk like a lawyer, when the question arises as to uses which in general tend to become deleterious to a neighborhood of homes, it would seem that the most liberal test open to us must be whether the use is one that is so necessary in connection with a house, so commonly to be expected with such a house, that it cannot be supposed that the ordinance was intended to prevent it. Well, parking strikes me as being exactly that. We all drive cars. Everybody in Falmouth drives a car. And if the owner wants to get to his lot, he's going to drive there. So it strikes me that parking is absolutely something that is allowed. I confess to being as confused by 240-23G4A as anybody else here. But I can tell you that the RV is parked in the middle of the lot. It's not in any of the setback areas, and it's not disturbing anybody that we're aware of, because one of the neighbors put up what looks like a 10-foot fence. So I don't know how much of a problem it could be. What the owner is asking for is that he be allowed to make use of the property that he purchased fair and square at an auction, foreclosure sale. Others were interested, I gather, but he was the winner of the foreclosure sale. So he owns the property. The building commissioner stands by his interpretation, and I'm inclined to agree with him, because how can we be regulating parking? Contrary to the assertions made, no, it's not going to be a paid parking lot, and he's going to take business away from other parking lots in the area going to the ferry. So we would ask the board to give full faith and credit to the building commissioner's decision on this one, and vote to allow it to stand. Thank you. Do you have any questions you wish to ask me?
Check with the board.
Yeah, I have a question. So where in our current bylaw does it show that we could have parking as a principal use?
I'm not talking about it as a principal use, but even if we want to go the principal use route, then he can use it for floriculture, horticulture, or agriculture, which he tells me he's more than happy to do. So there will be a principal use, and you can have parking.
But there isn't currently now.
No.
Is there does Mr. Halligan have a special permit to park the RV of that length and size on that parcel?
No, and his intention was not to leave it there.
You also said that they just purchased this at a foreclosure. So what is his intent use for the lot when he did the purchase?
His intent was that he wanted a place where he could leave a vehicle that he'd come from in California while he was on Martha's Vineyard, and then take it away with him when he left.
So he purchased the lot for parking use only?
The applicant did get it right that he seems to own an astonishing large number of pieces of property in various places in the United States. He wanted to have one here because he's been here a lot. He has a house on Martha's Vineyard, and so he decided to purchase a piece of property. Is there some other part of that question that you want an answer to?
No. Do you have a copy of the deeded easement by chance?
Yes, I do. What's wrong one?
can the board have this? That's okay. Yeah, of course. You want to?
We need something for the
We
file,
need a
I
copy
think.
for the file.
Yeah, we need a copy, so.
Okay, we need a copy for the file.
Keep it and I'll come by and,
Yeah, we'll
Okay,
get,
certainly.
she'll make you a copy, Rich.
by the way, that was my engagement letter I gave you. and Massachusetts requires that we have them.
Sure.
That was my copy, so I'll come by and pick that up.
Okay. We've got it, thanks.
That's all the questions I have.
Paul, any questions?
No, I don't have any questions. That's because, yeah, no, I don't.
Ken, any questions?
So if your client were to engage in some form of agriculture or horticulture, and he is not residing here, how would he do that?
I have no good answer to that. But while he's there, he could do it.
But does he spend any time residing on the property?
I haven't asked him that question.
What does the easement just say? Just can go on the property for whatever reasons we want? Whoever has the copy of the easement.
Together with all rights, privileges, and easements connected therewith and subject to restrictions and easements of record, and are hereby conveyed subject to any building and zoning law requirements which may be enforced and applicable.
So the easement subject, okay, just the easement.
No, there was a specific reference to a
Said
specific.
right-of-way is for the purpose of obtaining access to and egress from Oakwood Avenue. It's very brief.
In your reference to a previous court case, I think you said the judge ruled that parking should be allowed for a house or something like that. But there's no house there.
Well,
I mean, could,
the case that was referenced
yeah,
is about two gentlemen who wanted to put a private airfield on a 20-acre parcel. So it's not really relevant to this in its general principles as to what's,
it's not relevant. I don't think it's relevant here
well,
because it's a secondary or tertiary
right,
interpretation.
it was
I don't-
it was the applicant who brought it up, not me.
Anything else, Jerry?
No. At least not at this time.
With all due respect to your client's personal issues going on, does he intend on removing the RV in the foreseeable future?
I would say that it probably not until next spring, but I can ask him the question.
And you're asking us to uphold the building commissioner's decision in which he cites 240-23, which is special permit uses, and you admitted
There is no special
that there
permit.
is no special permit.
He-
So how-
He bought the lot. He came east to go out to Martha's Vineyard. When it came time to leave, he couldn't take the RV with him, so it's still there.
I understand that, but you're asking us to uphold the building commissioner's decision in which he cites the special permit section, and you admit to us that there's no benefit of a special permit on the property.
Well, you might have to take that up with the building commissioner.
Any other questions from the board or from Suri? All right. Thank you for your time.
Glad to be here.
We'll turn it to public comment. Any questions, comments, concerns regarding this project? Ma'am? And I'll just yes, up to the podium. And I'll just remind everyone, I know everyone was trickling in a few minutes late. We do hold public comment to 2 minutes each. Just wait to be recognized by me. Please come up to the podium, state your name and address for the record.
Hi, my name is Susan Madigan. I live at 8 Oakwood Avenue, and I wanted to say that I think parking lots do not feel like a residential use, nor do I expect to live with a parking lot in an area that I knew was residential. I know this person bought a lot, but I think the zoning laws have not changed and were in place when he bought it, so he knew the requirements of our zoning laws. We have many young children on the street, so I'm concerned about traffic. I'm concerned about safety, and I'm concerned about the impact on the neighborhood.
Thank you, Ms. Madigan. And since so many people apparently are here on this, I'll just reiterate that in the event that comments, questions, if they become repetitive, then the board reserves the right to close public questions, so.
For the record, I'm Thomas Madigan. I also live at 8 Oakwood. I'm the spouse of Susan, who was here first. Other than the heartfelt comments that she made, I would have to point out to the board that I agree. I spent the afternoon reviewing the Falmouth zoning bylaws. I agree with Attorney Wall that parking is only an accessory use to any residential property. You take a look at the zoning bylaws very clearly, the only sole permitted use in a residential district is single-family housing. That's it. I understand all of the common sense arguments that we all have to drive our cars and put them somewhere. But by itself, a standalone parking lot would require some sort of extraneous permits, and this one doesn't have it.
Thank you, Mr. Madigan. Ma'am?
For the record, I'm Allison Manchester, and I live at 39 Oakwood Ave. I actually share a driveway with the easement that runs back to the property. And I purchased my house as recently in 2016, before the lot had been purchased, and did a lot of research and due diligence on how the lot could be used. Someone parking an RV and possibly living in it was one of my worst nightmares. So did a lot of research and was told by every lawyer and every realtor who I spoke with that there absolutely could not be a secondary use on the property. And with respect to the lawyer who said Terrell is not disturbing anyone, I am definitely disturbed by the activity going in and out of my driveway.
I have a follow-up on that. If
Ms. Manchester? I think Mr. Foreman has a question for you. Sorry, and if I didn't relay that earlier, we can follow up with questions to members
So
of the public.
you mentioned activity going in and out of the driveway. How frequent were those or are those trips?
So I work full-time and I'm not home during the day, and I'm not sure about every single time someone comes in and out of the driveway. However, I'd say since Terrell has purchased the lot a year ago, I've seen him come in and out maybe 10 times, as well as other individuals who I don't know accessing the lot.
So not just him?
Correct.
And when you mean accessing the lot, do these individuals leave their vehicles on the property or anything?
No, they don't store their vehicles.
Or they come onto the property?
Correct. The only two vehicles I've seen stored are his van and his RV.
Okay.
Thank you. Any other questions for Ms. Manchester? Thank you. Anyone else? I'll just ask for everyone, just wait for me to recognize you before you come up to the podium.
For the record, I'm Greg Stone. I live on the house that fronts Oakwood. So the driveway is to my right, and the two houses, Tony's and Allison's, are in the back. The first time I saw the RV come in, it was 7 o'clock in the morning. The whole driveway shuttered. I was in the shower. I texted Allison and said, "Did you hear that?" She goes, "I didn't know what it was." He barely fits in the driveway. So we're kind of dead set against it. 2 weeks ago, I was raking the lawn. A car pulled into the back. A guy got out that wasn't Terrell, someone I don't know, took 5 bottles of what looked like Gatorade, car left with a woman and 2 kids in it. About an hour later, this guy comes up the driveway, and I'm like, he wouldn't give me eye contact. I don't know who it was. So that's what we're concerned about. That's all I got.
Thank you, Mr. Stone. Sir?
Good evening, my name is David Petrone. I live at 45 Oakwood Avenue. The back of my property abuts a small portion of this small lot, unbuildable lot. When the lot went up for sale, I was asked about it. I inquired from a numerous amount of people, and it was very clear that it was definitely a landlocked piece of property. And it is, the easement was always a question, and as you just stated earlier, that it's very vague of that easement. We were basically told when that property was built, the conglomerate of the three, which I have witnessed that entire venture, that that land would never be buildable, nor would it be accessible. It was landlocked. So I'd really love to see that document that you have to see how vague it is, because my theory is if the land is landlocked and there is a vague easement, he bought a piece of land that the only way he can get in there is on a helicopter. And that's really all I've got to say.
Well, what we have that was submitted to the, just to explain, what
It
was
does say
submitted
it's
to the board,
access.
it's an exhibit, a description of a property, which I assume is attached to a deed, and it does describe an easement.
But vague.
Access
Right,
to the property.
correct.
Anyone else wish to make any comment? Okay. Seeing no one else, back to the board. Have some board discussion?
I think we have enough information, actually, but.
I'd like to
I'd be-
discuss it.
No, yeah, we certainly need to discuss
yeah.
it. I'm just saying,
To close the hearing?
do we need to continue this, or can we just close the
I
hearing
think
and
we can
discuss?
close it.
Well, let's feel it out, see
Yeah.
where we're at with this.
Could I just say one more thing?
We typically just limit to one time up to the podium.
Even though I didn't use my whole 2 minutes?
Touche, unfortunately, yes.
Can I just speak from here, or do I need to go back?
No, I wouldn't, no more public comment.
Oh, okay.
Sorry, Mr. Petrone. All right. So how are we feeling about this?
I have not changed my mind. I think that there's no principal use. He hasn't indicated that he's gonna grow anything there. And I have a feeling that we should overturn the building commissioner's determination.
Ken?
I agree with Jerry. I found Mr. Wall's arguments persuasive, and I did not find the owner of the property's argument particularly persuasive. I don't see how he can conduct horticulture if he's not there.
Okay, Paul?
I don't consider the private parking of someone's personal vehicle a use of a property. If you buy a piece of land in Falmouth and you want to go to the vineyard for the weekend and you don't have a house there yet and you park your car on the lot and you go to the vineyard, that's a zoning violation? No, it doesn't constitute a use of the property. It's just so customary. Of course you can park your car or put your boat on your property. I mean, this isn't a commercial operation. At least it's not being represented as that. If it is, that's a huge problem. So there is personal vehicles. There's nothing regulating that. It's not a use under the zoning bylaw. That's absurd. I completely disagree with it. Now, and to speak to the regulation requiring the special permit, I've read that before because I have a camper and it caught my attention. And I mean, I don't have that in front of me, but provided you're out of the front yard setback, I believe it's permissible to have a camper on your property. I could be wrong. That's a separate issue that I don't, subject to setbacks. I just consider this a piece of the guy bought the lot. He has access to his property. It's not landlocked. He has the right of access from an easement, and he's putting his cars there. I feel bad for the abutters. That sucks. Who wants to look at that? Nobody. But that suddenly constitutes a use? No, it doesn't. Not under zoning law. It's not a use of the property. Commercial parking, no problem. These are his personal possessions. What about a wheelbarrow? What about bicycles? Bicycles? Are you kidding me? 2 bicycles on the property constitutes a zoning violation? Constitutes a use of the property? That's laughable. I agree with the building commissioner. You leave this stuff alone, because where do you take this from here? There's a lot of zoning violations out there then. I mean, come on, this is parking. I understand the abutters are upset about it, but there's no way that this constitutes a use of the property. Not from my experience, and I have a lot of it.
So I would agree with Paul if there was some kind of a residence, either abutting or on the parcel, because our zoning bylaws seem very specific that parking is only allowed as an accessory use. He made a statement this evening that they don't have any plan to have a residence on site. He might do horticulture, but again, he doesn't plan on residing on
Yeah.
site. There is no designated front yard. So if you're gonna deal with front yard setbacks, there isn't one. I don't know enough about the deeded access at this point, but I think the bylaw was written that way very specifically, so you don't get in these situations where you are parking these large vehicles. I mean, a 34,000-pound RV coming down a little 10-foot right-of-way on a site is gonna cause problems, and there just
Yeah.
isn't enough room there to,
No,
I think, build a residence and use it as an accessory use. You know, bicycles, I understand what you're saying, bicycles and wheelbarrows. I don't think people would have a problem with bicycles or wheelbarrows sitting on a site.
Nope, I completely understand your point. So when I buy a piece of land in Falmouth, and I live in, say, Acton, and I want to take the kids down to see the property on Cape Cod, and we park on the property, and we go in town for the day, that's a zoning violation?
So what did you buy the property for?
It doesn't
I-
matter.
I go back to the point that he did buy it at foreclosure, but he had plenty of time to review.
Why he bought the property is immaterial. It makes no that's not, we don't care about that. What's before us is that he's parking vehicles on the property. Is it a zoning violation or is it not a zoning violation? I am convinced that the parking of personal vehicles does not constitute a zoning violation, no matter how long they sit there, whether they come or whether they go. It's his property. He can park cars on it.
So if you're buying a parcel that you know you just want to use for parking, and you were doing a purchase.
We don't know what he wants to use it for. That's what's
Well, let's-
going
well,
on.
Well,
on
let's
it.
say he wanted to use it for purchase.
You're just
Say
gonna
for-
debate this
for
amongst
example.
yourself or include the board?
And then, no, and
I'm
then,
listening.
I'm gonna chime in.
and then somebody purchased the property, you would do due diligence to have somebody check in the zoning to see if whatever your zoning is for the parcel allows what your usage is gonna be. If somebody had looked through this and said, I may want to park an RV there, I may just want to visit, but I know I'm not gonna build a structure, they would see in the zoning bylaw that they need a principal use. I think it's pretty cut and dry, principal and accessory. I don't see where the,
I respect your opinion. I just disagree with it.
And Paul, I understand 100% where you're coming from. I tend to agree with the majority of the board, but the building commissioner's rationale was referencing a special permit use bylaw 240-23, which includes language about an RV.
And accessory use.
And accessory use, and with the admission that the property doesn't have the benefit of a special permit. So that's where I get hung up on it.
Okay. No, listen, I appreciate everyone's opinion. I'm just, I am going to vote to uphold the decision of the building inspector because these matters come up all the time. And, I mean, if you got the RV out of there, you know, maybe that would make a difference, I guess. But that's up to the property owner, and whatever this board decides, they decide, and the property owner uses his property at his own peril.
Okay,
Yeah.
I think we've all said our piece unless anyone else wants to.
Yeah, I
chime
mean, the
in
only
with some
thing I
more.
would add is that, you know, I think the zoning bylaws exist both to protect the rights of the owners and the rights of the abutters. And to me, this is a, you know, as you pointed out, TJ, the justification in the building Commissioner's own letter for allowing this is that it's accessory, and it clearly isn't accessory. And in terms of the word use, I don't see it defined in here. Maybe it's defined somewhere in Mass General laws, I don't know, I'll defer to Sri, but I would take a simple English approach. If you use something for a purpose, it has a use.
All right,
I have nothing further to add.
nothing further, okay, so we've all weighed in, and see where this is going. Does anyone want to make a motion? I think we need to make a motion to close the hearing,
Yes.
because we haven't done that yet.
Make a motion to close the hearing?
Second.
All right, that was motion to close by Jerry, second by Ken. All those in favor?
Aye.
Is that unanimous?
What was the motion again?
Close the hearing.
Oh, yeah.
Just closing the hearing.
Unanimous,
Unanimous,
definitely.
all right. And now, does anyone want to make a motion regarding this?
I have no one to look at, so I guess I have to make the motion to deny the, to overrule
There you go.
the building commissioner's determination that no special permit.
You're
is
granting the appeal, overturning.
required. That's what I said. Okay, thank you.
Granting the appeal, overturning the decision of the building commissioner.
I'll second it.
All right, so that was made by Jerry, partially by me, and then second by Ken. All those in favor?
Aye.
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 Opposed?
One, all right. 4-1.
Thank you, board.
The motion carries. That's fine.
Can we take a 5-minute break?
All right. We'll be on a 5-minute break just to let everyone out and address the rest of the agenda.
Oh, yeah.
Pick it up.
All right, and we're back from our break. Next up on the agenda is application 89-18, BATA, 360 Shorewood Drive in East Falmouth.
Oh, sorry. What, sorry. It's just, being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you hereby notified that Jeffrey Bada, trustee of Mansfield, Mass., applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3 and 240-69E of the Code of Falmouth to raise and reconstruct a pre-existing non-conforming single-family dwelling exceeding 20% lot coverage by structures on subject property known as 360 Shorewood Drive, East Falmouth, Mass. For our referrals, we have, let's see, we've got engineering, standard comments about runoff and things like that. Fire department, no comment. Water department, applicant, owner has to upgrade to a 3/4-inch water service to upgrade the 3/4-inch water service to 1-inch polyethylene pipe or better. Planning, no comment. And no comment from the assessing office. And
There's notes from verifying the height of the existing building from the architectural firm,
okay,
and a letter from the architectural firm with their opinion that the block foundation is stable enough to use for a two-story.
right.
But it is an architect, not an engineer.
Alrighty.
There's also
Oh, that's, I think that's for Hayway Road.
wrong project, okay.
Okay.
What file is that for?
All right, and for the applicant?
Thank you, Mr. Chairman and members of the board. My name is Laura Moynihan. I am a Falmouth attorney representing the applicant, Mr. Bada, who's here in the front row this evening. Along with him is Russ Crawford from GM Pietro Architects, who's the architectural firm for the project. So we have a presentation for you. This is an application under section 240-3 of the bylaw and 240-69E. So we have a non-conforming structure on the northerly lot line at the bulkhead. It's set back 5.1 feet. And we have an application to take the building down and exceed lot coverage above the 20% by right. So we have an existing 4-bedroom house without a garage. The house was built about 1966. The lot is 16,250 square feet. It is in a flood zone. The existing lot coverage is shown here, and there's an existing cesspool system. This is a photograph of the property. I'm sure you've been out there and looked at it, 'cause you usually do. So the applicant is looking to rebuild the house down, take it down to the foundation and remove the shed. The foundation is a concrete foundation, not a block foundation.
Sorry.
According to Russ. It's
That was
okay.
me.
No problem. The architectural firm has given that opinion. They have done that before. I'm sure that if the building commissioner, I guess, wanted a structural engineer's opinion, he could require it, or if the board was inclined to approve this project, they could condition the permit that way. But we felt, for the purposes of this application, that the architectural firm's opinion on that would suffice, and hopefully it will. The property is in a flood zone, so the existing basement will have to be filled and capped. The applicant would like to add a garage and add storage, which you'll see on the plans, that will be lost from the having to fill in the basement and not being able to have a basement anymore. So we have no increase in bedrooms. There are 4 bedrooms now, and the new house will have 4 bedrooms. There'll be a new 4-bedroom septic system with the project. The building height is around 25 feet, well below the 35-foot limit under the bylaw. The proposed lot coverage would be 4.8% over the 20% by right. And we have 36.1% coverage for structures, pavement, and parking, which is conforming under the 40% allowed. This is a colored copy of the site plan. So you see the existing home highlighted in green, and you'll see on the north or the top of the plan where the bulkhead is. So that's the non-conforming setback. The outline in the orangey pink area is the addition to the house that will conform to setbacks. So there won't be any increase in that non-conformity, and the new portion of the house will conform to the setbacks. And these are the elevations. These pictures didn't come out very well, but they're in your file, and we have them here. It's going to be a very attractive house. I would like to point out one error. This lower elevation on the plan, it was basically a typo noted as the south elevation when it's really the north elevation. So you see we have two south elevations. So this is this elevation is the south elevation, and we corrected that by filing a revised plan today, so I apologize for that error. So we have, as part of the lot coverage application, a very developed neighborhood, the Great Harbors neighborhood, a mix of 1- and 2-story homes. The house here is in keeping with the neighboring houses, I would submit. We have some photographs here. These are generally houses in the immediate vicinity of the subject property, 385 Shorewood. These are houses across the street. And again, this goes to the size and bulk of the structure being in keeping and compatible with the neighborhood. Here's some more, 355, 345, 351. This is 7 Joy Street, just around the corner. So these are homes that are at or exceed the lot coverage. 16 Joyce Street is one that the board approved a couple of years ago, a tear down and a rebuild, which is over the 20%. So again, I mean, these houses are in the style and keeping in the neighborhood. Here's 27 Joyce and 23 Sand Dollar Circle, again, over the 20% lot coverage. So the benefits here are the new septic system, the overall visual improvement to the exterior of the dwelling for the neighborhood. We have a 1966 home here, so there'll be a significant investment in this home. Flood protection and control, given the flood zone compliance and the landscape improvements. I would submit the changes are not substantially more detrimental. The standards of 240-216 are met. The site is adequate and suitable. No adverse impacts on the neighborhood. New septic system and the addition complies with setbacks. The lot coverage increase is not adverse to the neighborhood or site. And the renovated house is in keeping with the size and bulk of the neighboring homes. So that is our presentation, and I'll be happy to answer any questions.
Thank you, Attorney Monahan. Jerry, do you want to start us off?
No questions at this time?
All right. Ken, or you want to go back to you?
Come back to me.
All right. Paul?
I have no questions.
Up?
No question.
No questions.
Well, that was quick.
The setback, no, I got you, Ken, no worries. The setback that you referenced of the bulkhead, the 5.1 feet, will that be remaining?
Yes.
That's actually all I have, so. Ken?
Yeah, so you're also increasing quite a bit the total lot coverage by parking, paving, and structure. I'm just wondering if you would consider an alternative surface for the drive, or something that might increase the pervious surface.
Yeah, we're at 19.5% now, so almost 20% for structures, pavement, and parking.
You're going to 36.
And we're going to 36, where the next slide went. So,
On the, okay.
let's see what the plan is showing.
Says by 2 minutes.
Says bituminous on the plan.
Yeah, so it looks like the engineer calculated the driveway and the overall lot coverage. Excuse me, just one more.
Yes.
Well, I was gonna take out the driveway that's there and put in a stone driveway like all the neighbors have, with, you know, the paver block delineating the boundary.
Okay, so,
But then
we
that
could agree to
number
a,
would be
would lower, we could agree to a,
substantially, actually.
we could agree to a condition to that effect if you wanted to impose it, and then that would bring
Okay.
the lot coverage down, and we'd submit a revised plan to show that.
No sheds?
The shed will be removed, that's shown on the
Okay.
plan.
I guess those are my immediate thoughts. You said something about septic, but I might have.
There's an existing cesspool right now. So
Okay.
that will be replaced and upgraded to a new Title V system.
And that system is rated for
4 bedrooms.
4 bedrooms, and we have 4 bedrooms? in
4
there?
bedrooms existing, 4 bedrooms proposed,
Right.
so no increase in
You did
bedrooms.
say that.
Yeah.
Yep, okay.
I shut it off.
And let's see, last thing I'll ask about is setbacks. So
So the,
on the bulkhead, you got 5.1.
yeah, that will stay. That will remain, so no increase there. On the north lot line, 12.6, so the requirement is 10 feet, so it
Right.
conforms there. The rear is 28.7, so it conforms there. And on the south side, 18.2, and the front yard is 33. So all the setbacks will
setbacks.
comply,
Okay.
except that north one that is there now.
Bulkhead.
Yeah.
Okay. That does it for me.
All right,
One follow-up question.
sure.
Did you get an NOI from the Conservation Commission?
No, I don't think we are, well, we're in a flood zone. But we wouldn't be applying for an order of conditions.
Okay, I was just trying to think.
Yeah.
Maybe I have that street mixed up. I didn't go by. I thought there's a body of water not too far from that street.
I don't think it's within Concom jurisdiction. We would have had that on the
Great point,
plan.
yeah.
It is in a flood zone, so they might have to do an administrative review on it.
Was there nothing in the file and referrals from the conservation?
100 feet is the jurisdiction, so I think it's quite a ways from the water side there. Because you've got those lots across the street.
I was just looking on the plan. I saw some, looks like marsh. The end of the waterway is
Yeah, here's
delineated, and then there's some marshland.
Here's the GIS map. So there's probably this area here. And 360 is up quite a ways, almost in the middle of that plan. So I think we're
There's houses across the street.
we're outside of jurisdiction.
Thank you.
Any other questions from the board?
No questions.
Sari, anything?
No.
All right. Thank you, Attorney Monahan. Any questions, comments, concerns regarding this project? All right, seeing none, back to the board.
Motion to close.
Motion to close,
I'll second it.
made by Ken, second by Jerry. All those in favor?
Aye.
Aye. How would the board like to proceed?
Let's look at that end of the table for a while.
Yeah? Anyone like to make a motion down here?
I'd like to make a motion to approve the project as submitted.
Am I hearing a
Actually-
second from Bob?
Second.
Well, with findings and conditions, not
Yeah.
strictly as submitted. All right. Motion was made by Paul, second by Bob. Let's move on to findings.
So the applicant mentioned that the drive, they intended the drive to be gravel, even though it's shown as bituminous on the plan during the discussion, right?
It's existing 4 beds, remaining 4 beds with a
Upgraded septic.
upgraded septic.
Right at 27, and changes well below the
Height limit.
height limit and none of the setbacks. There's no
No increase in
increase in
nonconformity.
nonconformity with respect to setback.
Do you want to make a comment on the need for additional storage, which is what helps creep up the lot coverage? Because
Sure.
you have to get rid of the basement? Anybody?
Yes, they're required to fill the basement, therefore need additional storage space, which requires that they enlarge the footprint of the house. How's that?
Great.
Anything else, Paul?
No, I think we've covered it.
How about the structural engineer's letter? Be nice to reference.
I don't think it's
mean,
needed
I'm
myself.
comfortable with the registered architect's analysis.
I am, too, and I
They
think the building,
certainly they're certainly licensed to make those determinations, and he feels as though he wants to, so he can.
I agree with Paul.
Was that a finding? I missed something there.
Well, do we want to make do a discussion on it? I don't know if it's a finding.
Was that a finding that the architect submitted
Oh, okay.
that? Is that what you're saying?
That is a finding, okay.
With integrity of foundation?
Yep.
Yep.
Okay.
Applicant's removing the shed.
Yeah.
Kim would like that.
Right. The bailing principle.
Okay.
Anything else?
Move on to conditions.
Sure.
So
For
4
plans.
bedrooms remaining, four, I guess, no more than 4, is that? Gravel drive.
Sure. Per plans, but with our revised plans showing the gravel and the reduction in the lot coverage.
I'm sorry, you want revised plans showing,
Gravel drive.
Gravel drive.
Or shell.
Non-pervious.
Pervious surface.
Pervious.
Pervious surface.
with revised submitted? I mean, with
Calculations.
accurate lot coverage total?
Yes. Do we have to say anything about, subject to approved Title V? They have to do it anyways.
They have to do it as a upgrade per plans.
Sometimes you recommend we do it. All right,
Plan
so,
shows a new septic system.
oh, okay.
Anything else? All right, the motion to approve was made by Paul and second by Bob. All those in favor? Aye. Unanimous.
Nicely drawn plan.
I like this slide presentation. I like this slide.
Yeah, yeah, that is.
I'd like in the future, they give us a copy of them, because all the pertinent information is there.
Okay, up next we have application 93-18, Augusta, 366 Hayway Road in East Falmouth.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you're hereby notified that Susan J. Augusta of East Falmouth, Mass. applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-38G1B of the Code of Falmouth to construct a detached garage, creating space for more than 2 cars on subject property known as 366 Hayway Road, East Falmouth. For our referrals, we have the standard stormwater comments from engineering, no comment from the Conservation Commission, no comment from the Fire Department, Assessor's Office comment was full bath and kitchen in pool house, no comment from the Water Department, no comment from the Planning Office. And I think, we've got a letter in support of the project from the Castons, who are abutters to the property.
Okay, for the applicant?
Good evening. Christopher Lebhers, 99 Town Hall Square, for the applicant Susan Augusta. Susan's here with me tonight with her son Alan. They're both intimately involved, obviously, in the project. I was contacted back in October initially. You'll note that this is an application for a garage, but on the site plan, you'll see towards the westerly side of the site plan, a proposed 36 by 52-foot barn. We're in the AGA district, and the original thinking of my client was to build a barn. And, but she was very direct with the building department. She said, look, I think we're allowed to have a barn in an agricultural district, but we're not farmers. We're gonna store equipment, vehicles. I guess there's a boat that they intend to store. The building department took the position that if you're not making use of your barn as an agricultural use, that you don't qualify for having a barn. A barn would have been a larger structure. I think you can go up to 50 feet by right. So, we regrouped. I, at that point, was presented with building plans showing a structure that was larger than a two-car garage, and originally we were over 22 feet. So when I initially applied, I did apply for a special permit on two grounds, to go an accessory structure over 22 feet but less than 25, and an application for more than 2 vehicles. We subsequently submitted some plans to the board. I believe the plans that you now have before you. We are under the 22 feet, so we don't need any type of zoning relief relative to height. We are here tonight under 24038G1B seeking garage space only for more than 2 cars. It's a very large parcel, as you can see, 144,000 square feet. That's almost 3.5 acres. If you look at the notations from Cape and Islands Engineering, the total proposed lot coverage, if this structure were to be allowed, would still be at 4.7%. 20% is allowed by right in the district. We have open space for the town, from the town to the west. We have an abutter to the south, who I believe is here tonight in support of the application. You have a letter from an abutter that is in support of the application. We feel that we have a suitable parcel here, essentially because of its privacy and because of its large nature. So, why do we want it? Well, my clients have some vehicles that they'd like to store, and they have a boat that they'd like to store, rather than shrink wrap it and leave it outside in the yard like many people do in town. They want to keep it inside. So the use of the building is vehicle storage and a boat. Like any application for a special permit, we have to review 240-216. In this particular situation, I mean, I could go item by item, but the board is intimately familiar with 240-216. I don't think anything applies here. There's no problem with neighbors and views and vistas. I don't think we have any problem with congestion. I don't think we have any issue with traffic, any of the things that you'd normally be concerned about under a special permit. I certainly don't mean to make overly light of it. It's your call. But I'm prepared to answer any questions you might have. I think you have the site plan, I think you have the building plans, and you have me, and you have my clients, who are more than happy to answer any questions that I might not be able to. Thank you.
Thank you, Attorney Liberts.
Chairman Hurry, before the board gets into their questions, I just want to have the board remember that there is a building permit in the file for the kitchen and full bath within the pool recreation room, and I did submit that to the file. So that is a pool/recreation facility that was an existing garage that was converted. I don't want you to get sidetracked because of the referral.
So you're saying the existing, what's labeled existing garage on the plan is
Is
the pool facility?
Yes,
I
Okay.
think I can be on
And it's been permitted by the building department and approved.
Okay.
Thank you.
Hence not usable as a garage.
Definitely not usable as a garage, right.
Bob, do you want to start us off?
Yeah, actually, I just have one question. So it doesn't show on the plan, how are you actually accessing the garage?
The construction drawing should show doors on the sides. The front door would be like a residential.
But like a driveway? Yeah, there's no actual driveway?
Yeah, there's a It goes up to the existing garage is what he's saying.
See where the gravel driveway is? Correct, that's right here. It's going right.
Right around to the back.
It's all gravel.
That's it.
With Susan Augusta.
Paul, any questions?
No, I have no questions at all.
Ken?
I don't have any questions.
I don't have any questions.
The structure proposed itself, is it built on a concrete slab?
Slab, right.
Any heat or anything like that proposed?
My client indicated to me no water, no plumbing, but there will be electricity, and I believe she said heat. Yes.
Okay. And what's the overall height?
Change under 22?
21.9.
That's it for me. Any other questions from the board? Sorry, anything?
With the heat, there's no intent to make any habitable space within the garage?
No, nobody's going to be living there.
Thank you.
Any members of the?
I guess,
Sorry, Ken?
just, yeah. Just for the record. How many square feet is the garage?
I think it comes out to 36 by 52 is,
I could do that.
I have 1,600, 1,800 square feet.
1872.
1872.
Okay. And under which aspect? It's greater than 900 feet, or, yeah, it's greater than 900 feet.
Right.
Good.
All right. Any members of the public have any questions, comments, concerns regarding this project? Sir?
William J. Caston.
Oh, if you'd like to come up to the podium, please.
Way louder, way greater. That's why you said B.
Good evening. I'm William J. Caston. I'm joined tonight by my lovely wife, Mary Elizabeth. We live at 372 Hayway. We're actually kind of anxious to see the new structure. Everything that we've seen that Susan has done, Miss Augusta, has been just with total class and absolutely just adds total appeal to the neighborhood and everything that's going on up there. So we're very, very much with the project and would love to see it happen.
Thank you for coming tonight. Anyone else have any questions, comments, concerns? Ma'am?
I'm Roberta Rowe, and I live at 342 Hayway Road, and I am to the east of Susan's home, and I am all for the new structure.
Thank you for coming. Anyone else? Okay, back to the board. I think we've heard enough.
Ready to, I move to close.
All right, move to close by Ken. Is there a second? Second by Paul. All those in favor?
Aye.
And how would the board like to proceed?
I move that we approve this.
Okay.
Second.
Move to approve by Ken, second by Bob. On to findings.
Find that it basically enhances the usability of the site. Allows for storage of vehicles, out of the weather and out of view.
Don't forget about the boat.
Don't forget about the building.
The boat?
The boat, oh, well, boats are vehicles too, if you live on the water.
Sure.
It's consistent with 24038G1B.
That's for sure.
38G1B, yeah.
And I guess it's worth noting that the existing garage has been converted to
Other uses.
a different use, and therefore is no longer provides garage space.
Right.
In terms of conditions, 3, anything else in findings you'd like?
Did you get 24216 appropriate under that?
Say it is.
Appropriate under 24216.
Yes. I'll fill in the blanks.
Yeah.
Did you put garage will be heated but not used for habitable space?
Yeah, that's a finding, yeah.
Right, yeah, that the garage will be heated, have electricity, and there is no intent to create habitable space.
I mean, total lot coverage increases by 1.7%.
Yeah, well below.
It's minimal.
To 4.7%, right. Yeah, and then under conditions, I think as per plan.
Anything else? All right, motion was made by Ken to approve, second by Bob. All those in favor?
Aye.
Aye, unanimous.
Thank you.
They're all
Okay, that leaves us with our last application for the night, application 95-18, Kylie, 5 Plymouth Drive in East Falmouth.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 48 of the Massachusetts General Laws, you're hereby notified that John F. Kiley, trustee of Westwood, Mass., applied to the Zoning Board of Appeals for a special permit pursuant to Sections 240-3C and 240-69E of the Code of Falmouth to remove existing deck and construct an addition to the pre-existing non-conforming single-family dwelling on subject property known as 5 Plymouth Drive, East Falmouth, Mass. For referrals, we have the standard engineering comments. Conscom, no comment. Assessing office, no comment. Fire department, no comment. Planning, no comment. No comment from the water department. And I don't think there's no letters either.
You want to pass the plans?
Yeah.
And for the applicant tonight?
So I didn't bring a lawyer. Seems like everybody else did, but hopefully that's not an issue.
No, of course
No,
not.
it's not an issue.
So good evening. Thank you for the time. As you guys said, my name's John Kiley, my wife, another Mary Elizabeth, sitting in the back of the room. We are lifelong Massachusetts residents. We do live in Westwood, Mass. Right now, we have had a residence in East Falmouth on Plymouth Drive for the last 4 years. And we're here tonight to ask for permission to add some common living space to the first floor in hopes to make it a more common space, livable, so that things like Thanksgiving dinners can be had there as we look to become more full-time residents as we retire. So we're proposing, under bylaws codes 240-3C and 240-69E, building an addition to the first floor of our 5 Plymouth Drive residence. The addition will be added along the side, the east side of the existing house, which will be the kitchen and living room. And then those 2 rooms would be reconfigured, utilizing the additional space that has been added. The addition to the common living space will have no added bedrooms, no added bathrooms to the residents. There'll be no additional adage to the non-conforming, because it is a pre-existing non-conforming. The back right corner of the house is 3.8 square feet non-conforming, and the front brick stairs have 1.7 square feet of non-conforming, and neither one of those areas are where we're going to be building. We're building on the east side. In order to keep the structure and the coverage acceptable, we need to remove the existing freestanding 460 square foot decking in the backyard so that we fall within the 25 and 40%. Existing structure right now with the deck is 20.64%. After the proposed building and removal, will be at 20.9%. And the existing structure, paving, parking is 36.45 right now, and it would be 37 at the completion of the project. And that's the only comments I have.
Thank you.
Still feel like I should have a lawyer, but
You're fine. For the board's information, I did contact Mr. Kiley. Because of the elevation and the difference, he is adding a dormer. The inside of that, what I'm gonna call a great room type of situation, is cathedral ceiling. So it ties into the whole roof ridge. It was,
I have an example if you'd like me to.
we have it.
Oh, okay.
We have everything in the file. I was just clarifying my emails back and forth to you for the board.
I just said an example picture-wise.
To board questions. Bob, do you want to start us off?
No questions.
I have no questions either.
Ken, anything?
Come to me and you go back to him. I have no question. Gave you a lot of extra time.
I'm sorry, so is the height changing?
No, it's still gonna remain 23 feet.
Okay.
The addition's staying the same roof line.
Height's 23 feet. Bedroom count,
Stays at 4.
4 to 4. So you're really just creating,
In addition, that will have a cathedral ceiling.
yeah, and some living rooms type space.
Yes, we're reconfiguring the.
Living dining
Yes,
space.
yes.
Right.
Gotcha, and a nice fireplace.
That's the goal.
Okay, I'm satisfied, I understand it. Thanks.
Any other questions from the board or Sari?
No.
All right. Thank you. Any members of the public have any questions, comments, concerns regarding this project? All right, seeing none. Back to the board.
Well, I'm happy to move to close. I think there's much. Pretty
I'll second.
straightforward.
I'll second.
So, all right. Motion to close by Ken, second by Jerry. All those in favor?
Aye.
And how would we like to proceed?
I'd like to make a motion to approve the project.
Motion to approve by Paul. Is there a second?
Second.
Second by Bob. Moving on to findings.
Four-bedroom, remaining a four-bedroom. No new nonconformity. 2040-3C and 69E.
Deck is to be removed
Yeah.
to maintain lot coverage.
Addition has a cathedral ceiling to second floor, so no continuation of second floor.
Anything else? 240, 216, I suppose? Enhances the utilization of the property for property owner?
Thanksgiving dinner?
We'll have room to invite you.
Anything else? How about conditions?
Her plans.
And for deck to be removed. You want to maintain that?
Right. All right, so per plan and removal of
Deck
the deck
removal.
for conditions. Anything else? All right, motion was made by Paul and second by Bob. All those in favor?
Aye.
Aye. Unanimous.
I can't quite take it done.
We took care of the open meeting items, but Sari, there's plans up here that I forgot to
Yes,
mention.
you need to sign the Mylar for Gifford Street. I wish I'd thought of that while Laura was here. I could have just given it to her.
Did you bring a felt tip? You must have brought a felt tip, Jeff.
She did.
It's attached.
We're still conducting business here. If you want to move out of the meeting room.
Mr. Kiley? We're still doing our meeting.
Yep. No, if
That's
you want
fine,
to.
you're welcome to talk, just,
That's fine. So those are the Gifford Street, I believe, if the board would,
Who can sign this now?
the board members. We only need 3, so the 3 voting members that are here, I don't know who sat on it, I don't have it before me.
Use this fancy black pen?
Yes, please.
We need to sign
And
these.
is there a particular location?
Oh.
These-
Should have a board.
It's on the Board of Appeals.
There you go. Put today's date.
Suppose the date's on top and then our signatures after that.
Did I sit on it?
I think it was,
Doesn't matter. It's a closed hearing, you can sign if you want to.
This was the 40B.
Immortalized. Oh, yeah. What did people do before Sharpie?
Do you want to put those back on the cart?
Yeah, is that where they go?
and then you carry the cart back upstairs.
I'll sign.
No, the
If I can't
elevator's
sign,
working.
There's no reason for me not
That'll
to sign.
invalidate the plan.
Good night, thank you.
TJ.
Bob Dugan had to carry the cart down the stairs.
Carry the cart.
Is
The elevator broken?
Yes.
I think he was on the first one, but not the second.
Oh,
Maybe, I'm not, you know what I mean, so better overkill, right?
right.
Just in case.
Oh, I remember that. I was here for that.
What? It's only 3 signatures required on a 40B, but if you all want to sign.
The full
There you
force
go.
and effect of the
And they can't come back.
given our limited numbers these days.
And what is that in your hand? TJ?
Oh, extra pieces.
Extra
Oh,
pieces.
maps. Just
Do we-
the address.
Does this need to be signed? It's a hard.
I would, just in case. She submitted it. You can do that neat.
This is really nice.
Yeah, it's the Mylar.
Have we adjourned?
No, not
There was no
officially.
motion yet.
If we're waiting.
When we finish signing, we will.
Oh, that's right.
Same plan.
That's gonna go
Extra
back
pieces.
to Oakwood.
Right.
Where's,
Still sign. a hard copy.
Okay.
All right.
is there a motion to adjourn?
Well, I typically just close it.
I'll move that we adjourn.
Is there a
I'll
second?
second it.
Second.
All right, all those in favor?
Any discussion?
Seeing none. All those in favor?
Aye.
If we want, we can get into